And a disability carrier's failure to reference a specific plan provision changed the standard of review in an ERISA disability claim. Did you know that how a disability insurance carrier writes your claim denial can potentially change the standard of review that's used by a judge if this case ends up in federal court? Now, most people think that a federal judge's role is to determine whether the disability carrier plan made the correct decision, but that's not really what this game is about. The court's job is to determine whether the insurer had a reasonable basis for their decision, not necessarily whether they were right. So I want to break down for you the two standards of review that can be used in an ERISA disability case. First is the de novo standard of review. That's the gold standard for claimants. It allows the court to independently review the evidence and substitute its own judgment for the insurers. There is the arbitrary and capricious standard of review, and that's the carrier's get-out-of-jail-free card. It's much harder for a claimant like you to win because the court will only overturn the denial if it's without reason or it's erroneous as a matter of law. So how does the court decide what standard of review is applicable? It depends on the plan's language. If the plan gives the disability insurance company discretionary authority, then the arbitrary and capricious standard of review applies. Otherwise, the court will use the more claimant-friendly de novo standard of review. But here's the key. The failure to follow ERISA regulations can override the plan language and trigger de novo review. So, for example, under the ERISA regulations, a disability carrier is required to cite the specific basis of the claim's denial, and they are to provide you with a full and fair review under the regulations. If they don't do those two things, the court can apply the de novo review. And they don't have to make two mistakes, they can just make one. Now, if they change, obviously, the standard of review, that could be the difference between upholding or overturning a wrongful denial. It's really important if you get a claims denial or a termination of benefits that you're consulting with an experienced ERISA disability attorney. You only have 180 days in which to file an appeal, and as part of this process, the attorney is going to get a copy of your policy or plan, the summary plan description, and review the basis of the denial and the claims file to determine whether there might be an error, a violation of ERISA regulations that will change the standard of review from arbitrary and capricious to the de novo standard of review. And as I've said, that can make all the difference. If you have any questions, call us today at 727-894-3188 for a complimentary consultation. We can help you regardless of where you live in the United States, regardless of the nature of your disability, regardless of who that disability carrier might be. 727-894-3188.